obtain US patent protection as it relates to digital health technology. And so there can be, you can think about obtaining patent protection for different aspects of your technology or product. You can get patent protection for the devices, such as like point of care devices, diagnostics, or other hardware. But you can also obtain patent protection for software. In the US, there's been sort of shifting perspectives on what kind of software you can obtain patents on. And I'll share a little bit of insights on that. And of course, we can talk about it more in the breakout session. But typically, when you're thinking about patenting software, you target the functionality of the algorithm and not necessarily the specific code. And this allows for a broader protection of the software over something such as copyrights. And it can be helpful when the hardware or the device is conventional and not necessarily something new. And you can think about software that relates to analyzing patient data or healthcare IT, all those different aspects you can think about in terms of areas to patent in terms of software. In the US, we have several requirements in order to obtain a patent. You must meet the novelty and non-obviousness hurdles. Both of these relate to what is already publicly known. And as a just sort of practice tip, it's important to patent before you disclose anything. So definitely think about patenting if you're ever going to disclose something to the public as it relates to your company. And you also have to meet the eligibility hurdle. And this is where it's become more of an issue in the software space in contrast to devices and instruments where there's not as much of an issue. And I'll touch base a little bit more about that in future slides. So yeah, so what aspects of software can you patent? You can patent algorithms such as machine learning algorithms. Machine learning is sort of a hot topic these days in terms of being able to analyze complex data and derive some meaningful result. You can patent various apps or distributed computing systems. And in these instances, when one is looking at the claims and thinking about what areas to patent, it's helpful to think about what could be potential infringing activity by a competitor, and who is doing the various steps of the claim. And of course, this is something we can talk about in the breakout session as well. You can also patent the GUIs, so what's actually displayed, and how different presentations of data are generated. And also the data processing in terms of like various types of patient data or imaging data, as well as speech or text recognition. In particular with machine learning, there's sort of three different areas we often think about in terms of what area of machine learning technologies you can patent. You can think about patenting the model itself, and this might be amenable if there's a particular architecture, such as a new neural network architecture that you've developed as part of your technology. You could potentially patent the method of training the model, if that is of particular value to your company. And most often you're thinking about how you're using the trained model. And generally you're obtaining data, you're providing as an input to the trained model, you get some output, and then you're using that output in an interesting way. And that usually lends itself to a good set of claims to protect your technology.
Is it okay to ask questions in between?
I think we're trying to hold questions.
Okay, sorry.
No, it's okay. But yes, I am very interested in hearing your question. And then, so there's some challenges and considerations to think about when you're patenting software. There's the requirements that I spoke briefly about in the first slide, the novelty and non-obviousness requirements. And generally, if like the software is easily and freely available or in an open source library, there will be you can run into some difficulties in meeting this hurdle. And generally, if there's sort of a simplified approach of taking existing data, applying it to an off-the-shelf algorithm, and then showing the results to like an engineer, a doctor, a researcher, or a patient, that can present significant challenges in terms of getting patent protection. You really need to have some additional details in there that demonstrate that it wouldn't be obvious to do all the steps in the claim that software is doing. In terms of patent eligibility, in the US, we have law saying that abstract ideas and mathematics are not eligible, but even if that sort of step is determined, you can get a claim if the claim describes some what's called a practical application. And this is sort of an ongoing area of US patent law in terms of determining what is enough, what is a practical application. It can vary depending on the specific technology area, but generally good things to think about in terms of meeting this hurdle is what is new about the data, the algorithm, or the application, or the specific use of the technology. What is the context, and is there an action being taken from the software output, such as indicating that a particular patient might be susceptible to like a treatment or therapy, for example. And then another consideration is whether the software will become obsolete in a few years. We understand that patents take some time and to go through the patent process. It can take a few years to obtain a patent, but at the same time, you might be updating your software, and that patent application you filed might not have as much value. So that is something to keep in mind, is whether you'll be able to obtain protection on the subject matter that's the core functionality related to your business, and whether that core functionality is likely to change. And then I wanted to briefly touch base on the differences between patent and trade secret protection, because the two are completely different types, but they are important alternatives to think about in the context of protecting software. So patents, they have a 20-year term, where trade secrets, there's no time limit. With patents, you're given a right to exclude others, even if they independently develop the idea. With trade secrets, you don't have that kind of protection. Your competitors can independently develop that idea, and you can't use trade secret protection for yourself. And with patents, you have to meet these eligibility, novelty, and non-obviousness requirements. Whereas trade secrets, you can get patent protection or you can get protection on unpatentable subject matter, such as your data, which could be a huge pro for your business. And then also you should think about a cost benefit analysis for these two approaches. The cost in patents, getting a patent is costly in terms of preparing the application and the prosecution process, but there's also is likely some costs related to maintaining something a trade secret, because as part of trade secret protection, you have to take active steps to protect that information as a trade secret. And so you should think, one thing to think about is the cost benefits of both of those. And then so just lastly, some factors that would suggest patent protection or trade secret protection. For patent protection, if you're likely to get broad claims and you can get, it is patentable subject matter. If you have a disclosure plan, right? So if you disclose your information, you can no longer obtain trade secret protection for it. So disclosure pushes you more on the side of patent protection. If the technology is easy to reverse engineer or is likely to be independently developed, you would push more on the side of patent protection. And then for a trade secret, if it's harder to detect use or infringement and then enforce a patent, you might opt for a trade secret. The patent is likely to issue with narrow, low value claims. harder to reverse engineer, unlikely to independently be developed, all factors to push for trade secret protection. So with that, I will close and happy to take questions in our breakout sessions. Stop sharing the screen.
Okay, let me just share my screen. Can everyone see my screen now?
Yes.
Okay, perfect. Okay, so my name is Philipp Marchand. So thank you, Emily, for the kind introduction to patent law in general. And actually, after the change in the US law, European and US law are quite aligned on when it comes to software protection. So I will focus on European particularities when it comes to such claims and such inventions. So the patentability requirements are pretty much the same. So in the analysis, so whenever you submit an application to the European Patent Office, they will analyze the application and whether it's patentable, whether it's patentable with subject matter at all, whether it's applicable in the industry, novelty, inventive step, and enablement. So pretty much the same as in the US. However, the assessment of some of these criteria are different, as we will see. What's excluded from patentability, and the reason I'm showing that slide is that we see these objections quite often when it comes to software claims in digital health, in the digital health area, whereas in the pharmaceuticals or medical devices, we wouldn't see such objections because they are inherently technical. So these questions usually don't come up. Whereas here, when it comes to software claims, we very often see objections that the claim would relate to basically a mental act, for example, transforming data, or just a mathematical method because you apply a certain algorithm to data and you transform it by using a mathematical approach that's purely mathematics. Such things wouldn't be patentable in Europe as such, and therefore we often see those objections. And as you can see here under item C, that also applies to programs for computers. So we have this prejudice in Europe that people often come to us and talk to us and say, well, someone told me software is not patentable because it's excluded from patentability, but that's, as we will see, not entirely true. Because the exclusion from patentability only applies to software as such. So we cannot claim the computer program that is not technical. That's basically a program run on a computer. However, if we claim this as a method claim that is not, where the only technical effect is not derived because it's executed by a computer, but because it has a further technical effect, then it's very well patentable. So at least it's not excluded. It can still not be novel or inventive, but it's not excluded from patentability. So I put in one example here, and so this is published, of course, nothing secret. So we have a method for determining the propensity of cells to interact. So you're looking at a petri dish or something where you see certain cells, they are labeled, and you want to know whether the two cell types that you have labeled interact or not. Now you can basically count the cells, of course, and see how far they are in distance. And this is how it was done a couple of years ago. But now, obviously, we want to use software to do this job. So what is done here is we determine the number of interactions between cells of two subpopulations. We then randomly, that are labeled, we then randomly assign labels to cells in that petri dish, not because they are labeled, but just to see whether the labeled cells have a higher tendency to be closer in space in that petri dish. So that you would think is it's basically a mathematical approach, because you then compare the distance between cells that are labeled and cells that are randomly labeled. Nevertheless, because it has a further technical effect, you can determine the propensity of these cells to interact. That would be considered patentable, at least patent eligible in Europe. And it's of course done by a software, but nowhere in that claim it's mentioned that it's a software. So what I'm trying to say with this is basically that you have to generalize the software method that you have. So something you make, you program a software for, is executed by a computer, you just have to generalize that idea or that technical solution to a technical problem to become a method claim that is generalized to that problem, and where not the only technical effect is because it's executed, so the only technical effect is not derived because it's executed on a computer, but there's something going beyond that fact. So for example, executing a method on a computer and claiming, well, now it's faster or it's more cost efficient, that wouldn't be patentable because as such, because the only technical effect is that you have transformed it from something you can do by hand to something that a computer can do. But it becomes technical or it becomes patentable if you can derive a further technical effect, like now I can determine, like I have an improved method to determine the propensity of cells because my approach is better than what has been done before. However, and this kind of goes in the same direction with what Emily said, and we will discuss this further in the breakout, just to give you an idea of what the real problem is we see with software claims. And this is inventive step, because as you all know, artificial intelligence is a tool that is commonly used in digital health, but also in other software areas, and it becomes more and more prominent and becomes more and more accessible also. So there are many, many tools you can use. However, if you think about inventive step, you have to show a particular technical effect. So you have to show something that is surprising to the skilled person. And now the question is, how can you do that with an artificial intelligence, where you basically claim a method comprising an artificial intelligence step, but first you don't have the result, because that's something you still want to do. And how can it be surprising? Because artificial intelligence has been used before. And it's basically an application of a known problem, a known technology to a known problem. So putting this in a more formal context, in Europe, you would look for, in the assessment of inventive step, you would look whether the skilled person has had a hint to use artificial intelligence or a software program in general. Usually, the skilled person would be considered to use software because it's generally accepted as providing an improved result. And then the question is whether the skilled person had a reasonable expectation of success to arrive at the technical effect that you claim. And now the question is, how can you do that with artificial intelligence? And we will discuss this more in the breakout, just to give you a first idea here in this very short idea to make it more interesting for you to come to the breakout is, when you have a known problem, you tackle that problem with artificial intelligence. Just as an example, you want to find the best binder, for example, what many of you probably did is a docking experiment in chemistry where you try to find a good binder to a protein. And finding the lowest point of energy, for example. And applying artificial intelligence, so to narrow it down in an improved manner, is something that would not be considered inventive, because the skilled person would expect that the artificial intelligence tool provides a better result. And on top of it, you have no result, because the artificial intelligence inherently, such like a program that has to learn, becomes better with the more data you have, but you don't have the data at the time you file the patent application. So the question is, how can you show that there's a surprising effect if you have no results and if you're using a known technique? So this is the main problem we see with all claims that relate to artificial intelligence or methods that use artificial intelligence in Europe. And we will talk about this in the breakout session.
Thank you, Philip, and thank you both to Emily and Philip for their overview of patenting. We're going to shift gears right now to talk a little bit about trademark, and so I'm going to hand it off to Amanda Slade from Wolf Greenfield. Amanda, go ahead.
Hi everyone, my name is Amanda Slade, and I'm going to be presenting on trademark considerations for digital health startups. So I wanted to start off with a little trademark 101 and just to give some background. So a trademark can be a number of things. It can be a word, either an existing word or something that you've invented like Yahoo or Lexis. It can also be a name. So you have Sam Adams, who was a person, but then also Sam Adams became the name of one of the most famous beer brands. You also have symbols like the Starbucks symbol or a slogan like Nike's Just Do It slogan. And then we have some more fun non-traditional marks, and Simone is going to discuss these in greater detail during her portion of the presentation. But some examples include the roar that you hear at the beginning of MGM films. And you hear that lion roar, and that's how you know that it's an MGM movie. You also have color marks, and that includes the brown color that you see on UPS trucks, or the robin's egg blue that is on the famous Tiffany boxes. Another type is product shape. Here we have an example of that in the Hershey Kiss. And finally, one other example are scent marks. There's a company that registered the smell of the tennis ball that smelled like freshly cut grass. And what all of these marks have in common is that they identify and distinguish the goods and services of one company from those of another. And when you're deciding which marks to register and what types of trademarks that you want to protect, you should approach it from the angle of the user experience and how your customers will be interfacing with the brand. At minimum, this will probably include your house mark and the wording for that, and also your logo in a design or stylized version. A question that we often get is, why should I bother registering my mark? And there are a number of advantages. So first, it gives you nationwide rights across the US or in all EU member states. In the US, it also gives you the automatic right to sue in federal court for trademark infringement. And in the EU, getting a registration is essential to securing trademark rights at the EU level, and you can't acquire rights at the EU level simply through using the mark. Another advantage is that if you record your federal registration with Customs and Border Protection, they can detain and seize imported goods that infringe your trademark. And once you obtain that registration, it's important that you do everything correctly to maintain it. So in the US, that registration is perpetual as long as it's in use. And after you've had the registration for 5 years, you're required to show that you're using the mark. And then at the 10-year mark is when you renew the registration, and it's the same thing in the EU. Another important thing to keep in mind when you're choosing your trademark is you want to make sure it's a strong mark that you can both protect and enforce. So here we have the spectrum of distinctiveness. And at one end of the spectrum, we have generic marks. And a generic mark serves as the common or class name for the goods or services and is never registrable. So for example, you can't register escalator if you're selling escalators because that mark wouldn't allow you to distinguish your goods from others. Then we have descriptive marks, and those are marks that describe or immediately convey something about a feature, purpose, or characteristic of your goods or services. And there are some options for registering descriptive marks in the US, including that we have a separate trademark register for these marks called the supplemental register. However, that's unique to the US, and the EU IPO is stricter when it comes to descriptiveness refusals. So if you're based in the EU or planning to do a lot of business there, it's important to stay away from this type of mark. And these types of marks can be attractive in a marketing sense because they help promote the goods or services that you're selling, but they can actually hurt you when you're trying to register your mark or enforce your trademark rights. So for those reasons, you really want to be in one of the later 3 categories. And next we have suggested marks, which loosely relate to the underlying goods and services, but require some thought or imagination to reach a conclusion regarding the nature of those goods and services. So an example of a suggestive mark is the tuna fish brand Chicken of the Sea. So Chicken of the Sea, you see it and you think maybe this is associated with food, seafood, but it requires some imagination or perception to get there. Then we have arbitrary marks, and that's a mark that's a common word that has no meaning as applied to the relevant goods or services. And a perfect example of an arbitrary mark is Apple. So because it's used in connection with computers and electronics and has nothing to do with fruit, it's a strong mark as applied to those goods and services. And finally, we have fanciful marks, and those are coin terms that you've invented. And fanciful marks receive the strongest possible protection. One of the main differences between the US and EU systems that I wanted to highlight is how your use of the mark comes into play. And this is important to keep in mind if you're doing business in both jurisdictions. So in the US, use is required to obtain a registration, except for applications that are based on foreign rights. So if you apply to register your mark in the US through the World Intellectual Property Organization or WIPO's Madrid system, or based on a registration certificate from your home country, you do not have to demonstrate use of the mark before obtaining a registration. And this can be a major benefit for companies based outside the US. And just like use is typically required to obtain a registration, use is required to maintain and renew that registration as well in the US. And in the EU, the opposite is really true. So you have a system where use is not required to obtain a registration, and similarly, use is not required to maintain and renew a registration. And it's important to note that the EU IPO will never ask that you prove that you're using the mark. However, there are circumstances where third parties can require you to show that you're using the mark. So in the EU, third parties can petition to cancel registration for non-use after that registration is 5 years old. And also, if you're trying to use your registration to oppose another application, the party that you are opposing can come and ask you to prove that you're using the mark in order to successfully oppose that application. And this is largely the case in the US as well. So in the US, registrations can be canceled for abandonment, and also use is required to bring a lawsuit. So I briefly touched on the Madrid system in the previous slide, but I wanted to walk through what some of the advantages are when you're filing internationally and going through WIPO's Madrid system. So previously, if you wanted to file outside your home country, you had to file separate national applications in each country. That's no longer the case. So now you can file one application through the Madrid system, and that international application allows you to apply for protection in over 120 countries. And having an international registration not only streamlines the application process, but it also makes it much easier if you're trying to assign your rights or when it comes time to renew those registrations. It's also much more cost effective. So typically, filing through the Madrid system is a quarter to a third the cost of filing national applications. And filing through the Madrid system becomes increasingly cost effective the more countries that you designate. So if you're designating 2 countries through the Madrid system, you're not going to see as much of the benefit until you're applying for 5+ countries. And finally, I've talked a lot about what you should do, but it's equally important to talk about what you shouldn't do. So one thing I can't emphasize enough is that it's important to do a clearance search before you adopt your mark. So especially for a young company, you don't want to run into a situation where you roll out your branding and then another company sues you for trademark infringement, because especially as you're trying to get off the ground, you don't want to have to dedicate your resources and your time and money towards a lawsuit. Also, it's important once you have a trademark to use it correctly, particularly in the US, where demonstrating use is important, and the USPTO is going to ask you to provide specimens showing that you're using the mark. So first, trademarks should stand out from surrounding text, and ideally you want to display it in a different font style or color. And you should also use the TM symbol until you have a registration, and also the R symbol once you do have that registration. Trademarks should also be used as adjectives and should not be used in the plural, possessive, or as a verb. So for example, this isn't as much of an issue for Google, given that it's one of the most famous brands, but when people say that they're Googling something, that's an example of something that you should not do. Otherwise, that will be perceived as using it generically. And finally, you want to understand the differences between trademark versus trade name usage. So to use one of my favorite trademarks as an example, or law firm name, on the left, you have Wolf Greenfield being used as a brand. So it's in red font, it has a stylized and design element, and it's in the upper left corner of our website and is separate from the surrounding website copy. And on the right, we're just using it as the name of our firm. So it says 2021 Wolf Greenfield and Sachs PC, all rights reserved. So there, you just have it being used as a trade name rather than as a brand. And of course, you're going to have some of these uses, but these types of uses alone aren't going to support trademark usage. So you want to make sure that you have the types of uses that are on the left. And that's all I have. So with that, I will hand it over to Simone.
Thank you so much, Amanda. I would like to share my presentation with you, but I think you have to stop your presentation.
Okay.
Okay, here we go. So I hope you can see my presentation. I'm Simone Schäfer from Vossius Partner. I'm saying hello from Munich. And I brought you some examples of the digital health field, actually. Let me see. We start off with pure word marks. As you said, Amanda, it's more or less the same in Europe. And what is important, this German firm has protection by a Swiss trademark and an EU trademark. The most important thing you can see here are the classes. You will see them in the other slides as well following. The Biotronic ICS mark is used on the devices. It's used on the monitoring screen, as you can see on the excerpt of the website. And yeah, so it's a typical digital health related brand. This also applies to this trademark. It's a word and device mark. It's a word mark in a fancy graphic representation. Here again, you can see the use of the brand on the screen of a laptop in connection with the software. It's in fact for a smartwatch, giving assistance to people with respiratory problems, and the classes of interest in your field are always more or less the same. It's class 9 for software, and the diagnostic devices or medical devices in class 10, the software platform as a service 42 needs classification, and 44 medical services. Accordingly, this company also has a logo mark. This logo, you can see it on the app in connection with the word Livstone, and you can see it in connection with the packaging for a test kit of this company. You can see the classes are all the same again, so this may give you a very good idea when it comes to your own trademark protection in the future, or maybe if you check if your current trademark protection is in line with the standard. Have a look at the classes. What is interesting here, we had a great talk of you, Amanda, with regard to the genuine use. I think it's very doubtful here that the logo mark is genuinely used in connection with the word, because it has a completely distinctive character being used alone or being used in connection with the brand. So please be aware, align the use of your trademark with the registered form of your trademark. This is, I think, a very important advice for the future. Then I'm very glad Fabian, my colleague from our Berlin office, he collected very nice examples of non-traditional trademarks in your field. Please forget right away of what you see on the left side. The form of a medical device can be protected in principle as a trademark, but this should not be done. This is totally, I think, objected to design patent registrations. because it's very doubtful if this can ever be used trademark-wise. So the product shape for protection by a trademark, I think it's for many reasons, which is much too complex for now. It's not a very good idea. The company Novartis, for example, protected this 3D mark for an inhaler, which is a nice example because I want to show you a very fancy multimedia mark of the same company. I hope you can share the video and the sound it makes. So this is totally fancy, and I'm very happy, Fabian, that you found this trademark for me. I think when it comes to enforcement and also trademark usage, we will have a lot to expect from the courts in the future. These are very new trademarks. This, in fact, is still pending as an application. And another multimedia, much more simple, can be seen at the right side. It's a sound in connection with the word, and well, I think the word alone should also enjoy enough protection. So I'm not really sure why they protected this mark, maybe as a little experiment. So now when it comes to pure sound marks, you may have your own sound depending on what you offer to your patients. These kind of sounds create, of course, a very strong relation between your patients or the patient and your devices or your software, your apps, your monitoring device. So if you have created a sound, maybe you could consider protecting it. I give you some examples. I hope you can hear them. It's you see the big players in the market, Roche, Siemens, Medtronic, they all have protection for particular sounds. I hope you could hear them. I could hear it very well in my.
Simone, we can't hear them.
So,
we're not able to hear them, but maybe you could just
describe them. This is such a pity. So, but what we do, we share the presentation, and then you can you can listen to it later on. This is a motion mark, no sound, so I'm sure you can follow the motion of the graphic user interface. Here again, you can see the classes which are relevant. And also, I'm not so sure about the importance of this trademark. How it can be enforced will have to be seen. When is it infringed will be seen. When it is used as a trademark at all will be seen. But Sanofi obviously was of the opinion that it contributes a lot to their IP protection. Then, Amanda, you showed it as well in your first slide. We also in Europe and Switzerland know color combination marks, color marks, which give the consumer or patient the option to just go into a pharmacy and having no idea of the brand name in that minute, but then to show maybe to this fixo-mul stretch, which will be on the shelf more easily. Position marks, very interesting as well, help enormously to distinguish goods and packagings from competitors' products. So if you have a position mark, it's a very, very valuable asset to your IP portfolio. So in fact, the non-traditional marks, I would say, it's not really a thing for startups, but you should be aware of what is possible in terms of trademark protection, and maybe it's of interest to your company at a later point of time. We have, Fabian had found a very, very interesting article on the patient's relation with the products and how they look. And sometimes, of course, in your digital field, how the sound is like. So you have a very strong bonding, and it may be worthwhile to cover protection for this kind of bonding. What you should take home with you from this presentation, I think the most important thing is that you can achieve trademark protection for many different, well, not things, but like words, devices, combination of both colors, color combinations, product shapes even. The most important thing is that you have the scope of protection for your interest, for the goods and services of interest, which is in your case, I assume, the software and the apps, maybe sometimes the medicine, like in that case of the inhaler in class 5, then the medical device class 10, telecommunication, software as a service, and the medical services. So please be aware of this, that you take some time and some efforts to choose the correct wording of the list of goods and services. And then, as Amanda said before, it's also endless duration of a trademark right. So you have it for 10 years and then you can renew it as long as you are interested in this protection. And obviously some trademarks have a very long lifetime, like Johnson & Johnson or Bayer. They have been registered since decades, and the way they are used to date is still covered by the former registration, which you can see at the left side. So hopefully your brand will also survive the next 70 to 100 years. Amanda, you told me that the grace period and the use requirement is of interest to our listeners. So we are lucky we don't have the use requirement before registration, but in fact also the EU trademark owners have to use their trademarks to safeguard their trademark rights. Otherwise, the trademarks become vulnerable to non-use cancellation and cannot be enforced, because the owner of an attacked trademark can object to the genuine use. So then it's up to you to prove genuine use for an EU trademark within at least one territory of the EU. So the EU trademark is a very strong right. You have protection by a unitary right in 26 member countries now that UK left. And still it's sufficient to use it only in one member country. So I would say it's a very fair deal. The Swiss trademark has also a particularity. When you are domiciled in Switzerland or Germany, the use in Germany is also regarded as genuine use of a Swiss trademark and vice versa. I'm not sure if this is really of interest to you here, but who knows, if people are joining from Switzerland or Germany this session, this is very important information, I assume. And as from January 1, you also have to always consider the UK when it comes to trademark protection. And when you choose the way, as Amanda suggested, to go through WIPO by registering your trademark by means of an international registration, please consider to cross or to select the UK separately. It's not covered by the EUTM anymore. So thank you for listening, and maybe we meet later in the trademark room. So let me stop this so the next speaker can share the slide of his presentation. Thank you for your attention.
Thank you. And now we're going to move our focus to data privacy, which I know is a big question for digital health. And we'll be starting with the EU perspective with Monika Menz.
Thank you very much. Welcome, everyone. Digital health is data-driven, so that's why we need to talk about data protection. And we start off by doing so from the European perspective. So why are we talking about the European perspective if it's more or less a Swiss US webinar that we're having. The reason behind that is actually the territorial applicability of the GDPR. So if we look into Article 3 that defines when the GDPR actually is applicable, it says that if you have an establishment of a controller who's responsible for the data processing, or a processor, that is the entity that actually carries out the processing of the personal data on behalf of the controller, is based in the EU. So if we have a combination of a controller based in the US and a processor in the EU law is applicable. If we have a controller in Switzerland and a processor in the EU law is applicable. If we have a controller in the EU who wants to use a processor in the US, then again, EU law is applicable. And this goes on. So we have another issue here that says, regardless if the processing actually takes place in the EU, that means if we do have an entity based in the EU, and they say, okay, we only have an establishment here, all the processing of data is done in the US, so the processing doesn't take part here, then EU law will be applicable. That is actually a law of Lex Facebook. This is why it was introduced, because Facebook claimed for a very long time, we only have an establishment in the US, but all the processing of data takes place in the US, so EU law is not applicable. Vice versa, it also has some conflict, and because of the Cloud Act, for example, that EU secret services have access to data in the EU. That plays a role in the data transfer, international data transfer, what we're going to cover a bit later on. So if you have an establishment in the EU or as a controller, or if you use a processor in the EU that has an establishment there, then you're within the scope of the GDPR. That's easy. But now it gets a bit more difficult. If you don't have an establishment, but want to offer goods or services to data subjects in the EU, then you still have to comply with GDPR, and EU law is applicable. That means if you want to offer your application, digital health application, to EU citizens or data subjects in the EU, then the GDPR is applicable. So please note that data subjects in the EU is not equal to European data citizens. So data protection law and the applicability doesn't travel with citizenship. So if I travel to the US or live in the US as a European citizen, data protection law, GDPR, will not apply to me in the US. When I go home for vacation, or if you come over for vacation, European data protection law covers you. So it's really a question of territory. If you are in the territory, if you want to address data subjects in the territory of the EU, then the GDPR will apply. Another topic that we have here is monitoring data subjects in the EU. So even if you don't offer services, but monitor data subjects in the EU, that means if you try to analyze data of data subjects in the EU, perhaps not directly or rather indirectly, then the GDPR has you covered. The European Data Protection Board, that is the board of advisors on the GDPR, consisting of all national data protection authorities, said that, okay, monitoring and reporting on an individual's health status clearly is monitoring a data subject in the EU. So this would be a case of applicability under the specific legislation here. So if we have covered the scope, then the second question we have to ask, okay, are we actually talking about personal data? So personal data, and this is a bit different from the US. We have a very, very, very broad understanding of personal data, and the data protection authorities and the European Court of Justice have taken to the broadest possible interpretation of Article 4, Section 1 GDPR. It gives you a definition and says you either have a directly identified natural person or identifiable. That makes it already indirect, and that says it can be directly or indirect reference to an identifier, and an identifier can be physical, physiological, genetic, and others. So I have a client who provides X-rays. And they said, okay, but we don't have the name. We just get the X-rays from the patients and we analyze the X-rays. Yes, but X-rays are personal data under the coverage of the GDPR. Even if they can't make the direct connects of the X-ray to the natural person behind it, their customer who sent in the X-ray can make the connects, and that is already sufficient to cover this as personal data. It might be that it is treated as pseudonymous data. I'm sorry, it's such a difficult word. But this has additional safeguards, but GDPR is fully applicable to pseudonymous data in opposition to anonymous data. So the trouble is we don't have a definition of anonymous data in the GDPR. So if you truly have anonymized data, then GDPR is not applicable. But just giving it a key code is not sufficient for anonymization. So you have to combine various different anonymization techniques to achieve true anonymization. So it's not an easy task. And most of the data that I have seen that have been considered anonymous are not anonymous under data protection views. So that is a very critical step here, to make sure that if you anonymize data, that it's truly anonymized, or if you're not sure, that make sure that you comply with GDPR. So now we have talked about personal data. And when we look into health data under the GDPR, the requirements get even stricter. So we don't speak of health data as a category, but we speak of special categories of personal data. They're defined in Article 9, Section 1 GDPR. And for these personal special categories of data, which also cover genetic data, biometric data, data concerning health, specific requirements apply. So the question, if you can process a personal data, is even stricter when it comes to special categories of personal data. So keep that in mind. It's a very, very important restriction that you have to be aware of. Just briefly, let's briefly touch what you have to comply with under GDPR and what are the basic principles of processing data under the GDPR. One of the very and most important principle is the lawfulness of processing. So, and here lies a big difference between data privacy in the US and data protection in the European Union. We have, and this is an invention by the German Constitutional Court, this wording, and it has been taken on by the European Union by now, is we do have a preventive prohibition with the reservation of permission to processing of personal data. In plain words, it's prohibited until it's explicitly allowed. So you have to seek for permission to process personal data. If you can't find the permission, your prerogative is it's forbidden. So one of the possibilities is, how do I get permission to process such data, is consent. Fulfillment of contract, a legal obligation, vital interest, if consent is unattainable, and legitimate interest. This is a weighing of interest between the interests of the controller and the data subject, but it's not applicable for health data, so we're going to forget about it in a second. Privilege, we do have a privilege in the GDPR for processing health data for scientific research purposes. This requires appropriate safeguards, but we do have a privilege. So you don't have to ask for consent if you want to process health data for scientific research. Having said that, this is for scientific research only. If you want to make if you want to take your scientific research and make it into a product, then you need to make sure that your product, actually use of this data for the product, is in line with GDPR, and you lose the privilege if you start using the scientific research for financial reasons. We're talking about GDPR and the Unified European Data Protection Law, but in particular, when it comes to health data, there are opening clauses in the GDPR, which means that we do have the GDPR, but next to the GDPR, we have the national data protection laws in the member countries, and most member countries actually do have specific regulations in place, and one of the big opening clauses is actually for health data. Another big issue in processing of personal data under the GDPR is a purpose limitation. If you collect data for one purpose, you can only process the data for this purpose or a compatible purpose. You also have to be transparent. You have to keep in mind that you only collect the data and process the data that you really need to do so. So data minimization and accuracy are the data governance implications here. Storage limitation means that you have to delete the data when it's no longer used. And integrity and confidentiality refer to the data security. So we're missing here from the CIA trias the availability. This is not under GDPR, but we have other regulations in the EU that also require availability. Overall, the GDPR has a risk-based approach. The more risk that is possible to the data subject, not talking about financial risks of the controller or national risk, we're talking about risks for the data subject. The more risk there is for the data subject, the higher the requirements are, in particular for integrity and confidentiality, storage limitation and purpose limitation. The riskier it is, that the stricter the purpose limitation, for example, is. In the very beginning, when I said, okay, let's have a look at the applicability, I talked about data processor and controller. So we do have different roles and responsibilities under the GDPR. The controller is the one that is fully responsible, must comply with the GDPR. This is the one who determines means and purpose of the processing of the personal data. The data processor, on the other hand, has only limited responsibility to the extent of the obligation of the data processor. But insofar, he also has to comply with the GDPR. Purpose and means are determined by the controller, and he just has to follow the instructions of the controller. That also means there is no processing for own purposes. When we do have processing for own purposes, we're talking rather on joint controllers, and the European Court of Justice has set the tone for the joint controllers. And even if you have different purposes in mind, and not everyone is able to dictate the means of the processing, they can still be seen as joint controllers. And if you have a joint controller just as well as a data processor, you need to have a written agreement. And for joint controllers, they are jointly liable, jointly and severally liable to the data subject. This is, on the one hand, they are jointly and severally liable for the fines that can be incurred under the GDPR, but also for damages under the GDPR if someone doesn't process personal data in accordance with the GDPR. You can also claim damages as a data subject. Last but not least, I would like to cover the cross-border data transfer without the EU, US or Switzerland US privacy shield. So if you want to transfer personal data from the European Economic Area to another country, you need to have certain guarantees that there is an adequate level of data protection at the receiving entity and in the country as well. So one of the options that you have to prove that is an adequacy decision by the European Commission. We did have an adequacy decision for the EU-US privacy shield. And unfortunately, this privacy shield was annulled by the European Court of Justice. So we no longer have a adequacy decision. So we need to look for other options. And just as a matter of fact, in the wake of the ECJ decision, Switzerland also declared that the Swiss US privacy shield is no longer valid. We still have an adequacy decision for the data transfer between the EU and Switzerland. It's still valid, and with the new Swiss data protection law coming up in the next year, hopefully, the decision will be most likely renewed. So what other option do we have if we don't have an adequacy decision? How do I tackle data transfer from the EU or Switzerland into the US? So there was a second decision by the European Court of Justice on the standard contractual clauses. Those are data protection agreements between a controller and a processor, or controller and controller, that have been issued by the European Commission, have been adopted by the European Commission, and where the European Commission has stated that they are adequate. So in general, you can use them. However, the European Court of Justice said, yes, you can use them, but you have to make sure that the adequate level of data protection actually is fulfilled in the country. So when it comes to the US, the European Court of Justice claimed that because of the privacy legislations in the US and the competencies and powers of the Secret Service, it is impossible to uphold the adequacy decision because there is no adequate level of data protection. So the question really here is, how do you ensure that this is different as a private entity? And I think it's quite undoable, but the standard contractual clauses actually is the only measure that we do have at the moment to hold up a guarantee for the cross-border transfer between the EU and the US. So that was very quick and very dense. Thank you very much. And I'm looking forward to meeting you in the breakout sessions. I now hand over to the US side of the story.
Now we can get started. So that discussion of the shutdown of the privacy shield provides a good intro to the US part of the law. So the high-level theme on what's happening in the US is that this is a rapidly changing area and that there is very little definiteness on what is the current state of the law across the entire country. There's been no federal government action by Congress. There's no universal law across the entirety of the US for data policy, data protection. There were over 20 different congressional bills proposed in the last session of Congress. We just started the new session in this January with the following the recent election. And so possibly there will be more proposals, but there's no current law in place. The Trump administration over the last 4 years, some of the administrative agencies in the federal government did introduce some new regulations that applied to digital or data policy. And so we'll talk about some of those. And then you get some various state options, right? State by state within the US, there are different laws that take effect. We saw a big change in 2020 with the California law coming on board. But then even that, in this theme of a rapidly changing area, even that then evolved in November. So there was a big push across the industry to get up to speed on the CCPA, and then that was changed in November and became the CPRA with even more terms added. Washington State, so that's California. Washington State has its own law with different provisions than either of those. And so there's a lot of just variability and a lot of shifting right now. Looking at the short term, there's an opportunity for the new presidential administration and the agencies of that to do more regulations. Potentially Congress will get involved. Potentially Washington State will pass its law. So there's just a large opportunity to for there to be great variability and great changes over this in the next couple of years, and so we'll continue to monitor that. In the meantime, what do digital health companies need to know? This is a rapid area of development, big economic opportunity. All of you are starting your companies and need to know what is to be done. So we can take a look at some of the topic-specific laws here. We can look at what federal agencies have acted and what have they done. We can take a look at these state actions and look for trends. Try to identify best practices and try to navigate each of the prevailing regulations and prevailing laws, and see is there a way that we can look into each of these. The two topic-specific laws that people in your field probably hear about most often are HIPAA and the HITECH Act. HIPAA is a patient information protection act that goes back 25 years. HITECH is only about 10 years old. Both of them relate to protection and sharing of health information. An important piece of information to know about those, though, is that they only apply to certain what's called covered entities. The covered entities are health plans, which are in the US, the insurance companies, and similar. Healthcare providers, the actual hospitals, doctors, et cetera, and then healthcare clearinghouses, which are essentially people who provide services to the healthcare providers for doing things like medical coding for insurance purposes or other ancillary administrative functions for physicians. Those are the big covered entities that have to abide by HIPAA and HITECH. Then there's this general bucket of business associates of those that use individually identifiable health information for one of those three covered entities. So there has to be a business relationship with one of those three or a company that falls into one of those three buckets for a company to be considered a business associate. And a business associate is then performing some additional operations on behalf of one of those companies. So if you are not a doctor, if you're not providing administrative services to a doctor such that you would qualify as a healthcare clearinghouse, and you're not a health insurance company, then you're not likely to be a covered entity, and HIPAA and HITECH do not directly apply to you. But as far as what the provisions of those laws and the regulations that implement those laws say is that they limit the use of individually identifiable health information to certain ways. And the ways are probably unsurprising to people. It's got to be use that's ancillary to performing a medical service, treatment of the patient, diagnostics for the patient, et cetera, constrained to actually treating the patient and then getting compensated for services for the patient. You cannot then use the health information for a patient in some entirely unrelated way, absent an agreement from the patient, disclosure of that to the patient, and agreement of the patient that you can use the health information in that way. If you are a business associate, then you may be asked to sign a business associate agreement, which is required by the HITECH Act, which lays out for the business associate what the terms of the agreement are with one of the covered entities. Exactly what information is going to be shared, for what purpose, how is it going to be protected, what are the regulations or procedures regarding what will be done when there's a breach, etc. Privacy practices have to be disclosed, and in the privacy notice, which I'm sure everyone has seen by this point. And as far as security, which is ancillary to the protection of the privacy, there's a flexible framework. Essentially, there must be a risk analysis done that indicates what are the risks to this information and how can it be how can that risk best be mitigated? What are the available security measures that can be put in place, and then there must be a documentation of how that analysis was done and what the rationale was for why the security measures were adopted, and that has to be regularly updated as the information is used and the security measures that are available to people improve. So there's this flexible framework, which is a notion that we'll come back to a couple times in the U.S. Just hitting a theme for you all as far as what the topic-specific laws are, because there are a variety of options here that sounds on the theme of there being a lot of variation here and a lot of things to get your arms around. There are laws regarding collection of information regarding children under 18. There's laws regarding what to do in an educational context. There's laws regarding how to contact consumers with commercial messages by email or by phone or by text message. There's additional laws regarding financial privacy that govern what to do if you're selling financial services or doing background checks on people or collecting debts, etc. We won't talk about those in detail given the digital health focus of today's presentation, but wanted to at least make sure that people were aware that, again, there's just a lot of variation. There's no single overarching rule in the US. The federal agency actions I spoke about earlier, we'll touch these briefly. The FTC in the middle of the Federal Trade Commission is the one that I'll focus the most on. So there's the US Federal Department of Health and Human Services. They're the ones who implemented the rules regarding the privacy framework and the security rule, which we talked about in the earlier slide. So there's regulations there, and they are constantly looking at those and releasing new guidance. The Food and Drug Administration for medical devices, where there is software and there are cybersecurity risks, has released guidance on best practices for security. It's just guidance at this point. But as far as what the security is to protect the digital health information that you're processing, you can look at those recommendations. As I said, the FTC is the body in the US that at the federal level is perhaps the most active right now. They are tasked with regulating companies and ensuring that they are not doing anything that is unfair or deceptive for consumers. And that's a relatively broad mandate, broad instruction from the law. And they've interpreted that in recent years to apply to data privacy and adequacy of protections for data privacy. And in particular, they've taken action against companies who are acting in ways that are contrary to the public statements they make to customers. So if a company has a data privacy policy or privacy practices notification that they give to customers, and then do something that's inconsistent with that, the FTC has taken action against company for that inconsistent action. And that inconsistency may be something that's just plainly contrary to the terms of that policy, or something that's just not disclosed, right? Any sort of difference in what the company's doing versus what the privacy notice to customers says is potentially actionable by the FTC. And that includes not sufficiently notifying customers about breaches and not maintaining sufficient security that leads to a breach. And sufficient security has been interpreted, again, going back to that flexible framework, what are the risks and what are the measures that would be adequate to protect that risk? And companies just need to be sure that they are being mindful of their choices and making good choices and have a supporting rationale for those choices. The couple other entities here that I'll just mention briefly in the interest of time is that we have flexible frameworks coming out of other federal agencies, NIST, flexible frameworks coming out of NTIA, and both of those touch on privacy and security. That if there are rather than some of the very prescriptive laws that come out of the GDPR or out of the California laws or Washington, as far as what is specifically to be done or not done as far as privacy and use of information, these federal agencies instead talk about what are the risks of this information to the patient or to the person that this information relates to, and then make sure that the company is thinking about the right things in terms of how that information is used, how it's locked down, what's disclosed to the consumer, etc. So as well, the Hipaa, California, et cetera, are strongly locking down or putting requirements in place as far as what can be done and cannot be done. Recent federal action that from the Trump administration is focused on kind of flexible frameworks and what are the things that people should be thinking about. We'll talk very, very quickly about state laws because, again, this gives you a contrast with the flexible approaches, again, with the theme of there's a lot of variation in the US. The California Consumer Privacy Act, landmark law in the US, applies to companies that do business with California citizens or households or residents. Introduced a lot of consumer rights that were new for the first time in the US that resonate a lot with what was in the GDPR. There are some differences, but it became important because of the importance in California, large state, large economy, lots of companies based there, lots of companies doing business with California residents. And so if there is personal information about a California resident that a company is processing, all of these regulations start to apply. And a lot of companies that do business with California applied them across the US rather than only limiting it to California. So there's a big effort in 2020 to come up to speed on the CCPA. And then almost as soon as that came out, there was an effort to further expand rights, and that passed by ballot initiative, going straight to the voters rather than going to the legislature, the government. And that came down in November, which introduced additional regulations and additional rights in consumers. I'm just going to move very quickly through this. One of the important things, or two of the important things that we can talk about here for the CPRA is the regulations related to automated decision making, that if there's AI and machine learning in place, then consumers can learn what decisions are being made with the AI and machine learning and opt out of their information being used there. It's very high level right now. It only came out in November. And the last bullet point on this slide is there's a new agency in California that will be introducing new regulations. The CPRA will come into effect in 2023. And in the next couple of years, I assume we will see more about the AI and machine learning. And so watch out for that. And then relevant to digital health companies, again, there's additional regulations, additional strict usage limits on sensitive personal information, which would touch on health information, genetic information, et cetera, to make sure that consumers are aware of what information is being collected and aware of what's being used. And I mentioned earlier, Washington Privacy Act, again, different state, different rights that may come into play that hasn't yet passed. High-level takeaways. Make sure that whatever you're telling your consumers, your customers, you're doing actually aligns with what you are doing. Don't have any inconsistency there. Make sure that those disclosures are comprehensive and you're getting consent from the consumers for what you're doing, and minimize what information you're collecting for the task that's being performed. Do a flexible risk analysis. Make sure you're aware of what the risks are to the customer of inadvertent disclosures of that information, and make sure you're either not collecting high-risk information you don't need, or locking that information down to ensure that there's no breaches. And I will stop there so we can move over to the breakouts.